Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to Our Curious Amalgam, the podcast for the American Bar Association Antitrust Law section. My name is Christina, and today's episode is, will that be cash or credit? Swipe fees and their critics. The credit card industry has been the subject of increasing antitrust scrutiny, particularly as the overall cost of transacting has declined. In this episode of Our Curious Amalgam, we'll explore some of these key antitrust issues facing the industry today. Joining me today is my co-host, Matt Reynolds. Hey, Matt.
Hey, Christina.
Welcome. Happy to have you, and also very excited to welcome our guest today. Hard to imagine a better person to speak on this topic. We have Doug Kantor with us. He's General Counsel of the National Association of Convenience Stores, otherwise referred to as NACS. And prior to joining NACS, Doug was a partner at Steptoe & Johnson, where he served as outside counsel to NACS and other payment and retail merchant organizations, among others. Doug is a foremost expert on payment systems and fees and has testified before Congress on these matters. Welcome, Doug.
Thanks for having me.
So, before we get into the main topic of today's discussion, Doug, I wanted to ask you a couple of questions about your career thus far. As you may know, our podcast attracts a lot of listeners who are at or near the start of their legal careers. And I always think it's interesting to find out what first led experienced lawyers like you to get into the field that you've become known for. How did you first get involved with these issues of credit card networks and payment processing and swipe fees?
It's complete happenstance. I think planning out your career does not make a lot of sense. My advice to folks is always work with good people who are interesting and things will work out. I first got into these issues really in the early 2000s. I was working for a smaller law firm, Collier, Shannon, Scott. And some of the partners and I were working with NACS in particular, but some other trade associations representing retail as well. And those associations said to us, hey, these credit card fees are a big issue. We want to see what we can do on them. And there was a project as an associate that seemed interesting. And next thing you knew, we were off to the races.
That's great. I see from your bio that you've had a long history of practice in private practice, but only recently went in-house, working now in-house for a former client that you serviced in prior practice. Can you talk a little bit about what that transition was like from private practice into an in-house position?
Yeah, it was probably a little bit unusual for me as opposed to other folks because I had been essentially the in-house counsel for NACS as well as a few other associations for years. I'd been representing NACS for over 20 years. And so my transition in-house was much more like a continuation of what I had already been doing for them. But there certainly are differences doing it in-house versus doing it as outside counsel. One is you only have one client, but I would warn people that that's somewhat in theory because you've got different areas around your client's offices that may have different views too. So it's always a balancing act as a lawyer either way. One of the biggest things is not having that colleague at the law firm next door to just pop your head in and say, hey, can I bounce this question off of you? Those informal interactions are a big deal. And when you're in-house, there's just a little bit extra transaction cost to get to outside counsel and have the same interactions.
I can imagine one of the other interesting aspects about your position is that as the general counsel of a trade association, you also have all of these constituents who aren't necessarily directly your clients, but also obviously weigh in on policy decisions and initiatives that you handle. How have you found that to be in terms of your career development? Has that always been a challenge, or has it been something that you've been doing for so long that it's just second nature to you?
A little of both, frankly. It is always a challenge. Look, the most interesting and complex part of what any lawyer does is working with people. People are complex. And so it has become second nature at this point. But there are days where you think, geez, we've got members who think about these things very differently. How are we going to deal with that? And you got to work through how to talk to them and how to really get through the different aspects of a decision process to come up with a good answer.
Well, that's great. Again, I really appreciate getting that perspective, especially for our young lawyers who are listening. Turning over to the main substantive topic of our discussion today, we're going to talk about swipe fees. And that necessarily involves a little bit of a discussion about credit card networks, how they came to be, and what their role is today. Swipe fees in particular are something that, as far as I know, the general public is only sort of vaguely aware of it. I can say in my own experience as an antitrust lawyer, I became aware of these issues a number of years ago. But as a consumer, it's really only been in the last couple of years that I've started to see here and there examples of this issue actually being a matter of public awareness. For example, there's a store that we frequent in our area that happens to have a sticker on its cash register saying that it prefers one particular credit card type over the others. And I think that's the only instance I can think of that happening. But if you could maybe give us a little bit of an introduction to, what are these swipe fees? So not only from a legal perspective, but just from a consumer perspective.
Sure. So look, credit cards really started, Visa and MasterCard started them way back late 60s, early 70s. You might get a line of credit from your banking institution, but those banks wanted to figure out, how do we get people an easy way to use those nationally, not just in the local community where our bank does a lot of business? And so Bank of America had Bank AmeriCard, which was the largest at that time, and they worked with the other major banks to turn Bank AmeriCard into Visa. And what Visa does, and what MasterCard then did and continues to do today, was they acted as really an association of all of those banks. And they were the interconnection point, the data line, if you will, between the bank that gave the consumer a credit card and the merchant's bank. And you had to make sure that the dollar figures could get passed back and forth in a way that was efficient and accurate. And you had to make sure certain things were standardized. How many numbers were going to be on a card? What type of data format would the information get sent on? All those types of things. It's incredibly detailed, and there are hundreds and hundreds of pages of rules that Visa and MasterCard published to cover that. But one of the things they decided back then that has been really the kernel of controversy in all of this for decades since then is they said, gee, we need those banks to have a financial incentive to give customers a credit card. Now, that wasn't necessarily obvious, right? Because you'd think, well, their incentive is they have a bank customer and they charge them interest or fees or what have you. But the decision was that wasn't enough because it was somewhat expensive to market and acquire those customers and get them signed up. So we need this financial incentive. So what Visa did and then MasterCard did is they said, we're going to set the amount of a fee that the card issuing bank automatically gets every time somebody uses the card somewhere. And thus began this huge controversy where for many, many years, merchants have complained about how high those fees are. And then there's lots of other rules that make those fees somewhat difficult for consumers to see and difficult for them to get price cues. But that's really the original piece of this, where merchants have long said, wait a minute, those banks are big, independent, competitive players, and normally they set their own prices and compete with each other. But here, if all of them are under the umbrella of a Visa or a MasterCard charging the same price, that sure looks like price fixing and a problem. But that's really how they started, was Visa and MasterCard saying, we need to incentivize that side of the market. I would just note, interestingly, that when ATM cards came out, and before we called them debit cards, they were just ATM cards, and all you could do was stick them in one of those machines and get some cash out. The view was, oh, actually, the incentive needs to go the other way, which is to the ATM operator to incentivize them building out an ATM network. And so there's a similar fee on ATM use, but it goes to the ATM operator rather than the issuer of the ATM card. So that really is how all of this got started, and what started what has been a very long, interesting story for antitrust lawyers all around the country.
Yeah, I wanted to ask too. There's another major player that has figured in a lot of the antitrust headlines that we've seen over the years, and that is American Express. Can we talk a little bit about where they fit into this story? How they operate differently, or where they come onto the scene, so to speak.
Yeah, the American Express is a different animal, and I'm really glad you asked that, because American Express is not just a network. They are, in fact, the bank that gives the consumer their credit card, or really they started with charge cards, right, where you had to pay it off every single month, and that's still a big part of their business. But for American Express, they didn't pull together thousands of banks that issued their cards, and they didn't set prices for thousands of banks. They just set their own price, and they just said, hey, we are going to give consumers these credit or charge cards, and merchants, if you want to take them, we'll talk to you. You can have a deal with us and sign up for it. So it's a very different looking proposition from an antitrust perspective, even though most consumers don't really pay attention day to day to those types of differences. It is very significant. And what it's meant over time as a practical matter is American Express bargains directly with merchants. And obviously that looks and feels differently from the antitrust law perspective.
Sure. You also mentioned ATM cards, which we all remember. And I guess, as you said, we all call them debit cards now and think of them that way. One of the things that I can recall growing up early on having an ATM card is when you would go to an ATM, there would be that sticker that would have all these different network names on it. And my favorite was always, I think, called Shazam. But if you could talk a little bit about, what's the status of all those networks? Are those all really part of the same thing? Are they distinct networks? What's the story with those?
Yeah, so all those different networks are independent companies that on debit transactions compete with Visa and MasterCard. And they have competed with them since they started out as ATM cards, or I should say, since Visa and MasterCard came into the debit card market really in the 1990s, then they became competitors. Before that, it really was just NICE and Pulse and Shazam and all those names that we sort of vaguely know from either seeing them on the back of a card or seeing them on an ATM. What happened when Visa and MasterCard got into the market and made these debit cards and said, hey, you can use this at the store, not just get cash and use the cash at a store, is they started adding these interchange fees or swipe fees to debit transactions. And pretty quickly, the bank said, hey, this is a good deal for us. We love that. And we're really going to use Visa and MasterCard more and more and use those other competitive networks less and less. We had at one time dozens and dozens of those independent networks. In fact, it may have been as many as about 100 of them regionally, other specific uses, et cetera. Now we're down to about a dozen that are left. They slowly went out of business. And the 2010 law, the Durbin Amendment, which passed as part of the Dodd-Frank reform, stopped exclusivity deals on debit and said, hey, Visa, MasterCard, you can't buy up all the real estate and say you're the only network on a debit card. You got to give some room for at least one competitor on each card. So that really breathed new life into these smaller companies. And Shazam is still at it. They're pretty big in the Midwest in particular.
Just fast forwarding now to 2023, the financial markets have obviously evolved significantly. The ability to create these networks that may have justified the need for some fee, back when credit cards were new and people were a little reluctant to use it, have decreased significantly. Are we seeing innovation in the market today around payments that make these fees obsolete? Do we think that they still need to exist, but at a lower amount, right? So what, there's Stripe. Every time I go into a store, there's a new app happen. I don't know if it has anything to do with my Visa or MasterCard, or if I can just use them, but help us understand the current state of play with respect to payments and these fees.
So payments, if you look at it from the outside, should be a market that is incredibly ripe for disruption, really technological disruption. There are all these different interesting things happening out there. So for example, in a lot of the world, these transactions happen with people's cell phones. They're not carrying around plastic cards. They're using those phones and have apps on there, and some of those may even be, in certain cases, cryptocurrencies that people are exchanging. Some of them are other types of, let's say, interesting forms of currency, like a WeChat Pay, and there's all kinds of sort of domain-specific types of payments, and others are just ways of transacting. But a lot of the world has really skipped ahead of us in those ways. The US is definitely experimenting with them. There are other little innovative ways to pay. Most of them here, though, have still been essentially the equivalent of putting one of those little plastic sleeves on the back of your cell phone and sticking a card in there. And that's really what people are using, because Visa and MasterCard are so dominant in the US, they've been able to hold back a lot of that innovation and still dominate the marketplace. So given that the biggest service Visa and MasterCard provide is actually just a data line between banks, it does look like that should be obsolete. Any of us, even as individuals, much less banks, can pick up our little cell phones and connect with each other without much problem at any time of the day or night. So that service and the fee going along with it are really big question marks at this point and add a lot of inefficiency. But because Visa and MasterCard are so big here, we really haven't seen that disruption hit yet. And there's a big question as to whether we will or not.
I know we're going to talk about some of the pending actions that MasterCard or credit card industry is facing, but putting on sort of your devil's advocate hat on for a moment, sort of what is the ongoing justification? What are Visa and MasterCard's argument for, the continued use of swipe fees?
So look, they argue that this system gives a lot of value both to consumers and to merchants. Consumers have a convenient way to pay, to draw on a credit line, and merchants get the value of payment up front, and they don't have to worry about as many of the problems with consumers paying, not paying, et cetera, as they might in other circumstances. So they really argue that, one, there's that value, and that they've balanced these sides of the market appropriately. Merchants see that very, very differently. Nobody argues that we should abolish credit cards any more than if they argue about, say, price fixing or antitrust violations in some other market, that they're saying, oh, we should abolish that product or service. That's not the point of antitrust law. So we get that, but certainly the history of increases in price here and how it happens, I think, have led us to seriously question whether the way this works is appropriate for everybody.
It sort of seems to me kind of like using a fax machine nowadays, or, when I started as a first-year associate at my old firm in New York, the firm still had its telex number on the firm letterhead, which I thought was pretty cool, but also a little bit arcane at that point.
Yeah, absolutely. These things all should be getting a real technology update. When my first son was born, I had a pager to make sure my wife could reach me at any time of the day, and those things aren't so necessary either.
And to your point about card technology, too, I can recall over 20 years ago living in Europe and everyone kind of looking at me oddly because I had the primitive credit card that didn't have the chip in it already, because, I lived in Germany, all of my friends in Germany had chip cards and I didn't.
That's right. No, look, in part because of these dynamics, right? Europe beat us by like 20 years to the chip cards. And as I said, much of the world Asia in particular, but lots of regions are beating us to the mobile payments and mobile phone usage. And other places are doing things like open banking that are remarkable. I mean, in fact, you can, with a person in India, often people asking for money on the streets, if you agree to give them money, they'll show you a piece of paper with a QR code that you can scan to send them money instantly. That's a lot different than the way things work here.
Wow. Well, we did want to talk a bit today, obviously, about what's going on right now. Of course, we could talk for hours about the massive history of congressional action, DOJ involvement, other regulators, and private litigation. But could you give us a sense of sort of what's going on right now, what's percolating today, 2023?
Yeah, there are a number of things that are percolating right now. So it is public that the Department of Justice Antitrust Division is investigating the credit card networks for potential antitrust violations relating to what they do on debit cards and whether there's unfair competition with those other networks you mentioned previously, the Shazams and Nices and Pulses of the world. And that investigation's been going on for a while. The Federal Trade Commission took comments earlier this year on a consent decree with MasterCard around MasterCard's behavior on the Durbin Amendment and again, sort of competition among those networks on debit cards, but specifically whether they're following the Federal Reserve's regulation implementing the Durbin Amendment or not. And there's long-running private litigation in the Eastern District of New York that was filed in 2005. There's actually a consolidation of more than 50 class actions. NACS was one of the lead named plaintiffs in one of those cases, and for many years was listed at the top of the line in that case. There's been many trials and tribulations over time, but the case is still going. And actually, we are awaiting summary judgment in that case, which could come any time now. We'll see. There was just a status conference this month, and it's still going.
Well, the next time I talk with clients about how long things take in federal court and they're concerned about it taking a couple of years, I guess I can use that as an example. It could be a lot worse in terms of timing.
It is definitely an example that some of the lawyers in the case will use with other clients. It includes a failed settlement that was overturned by the Second Circuit, and in fact, there's now a financial settlement of monetary claims, but injunctive relief claims are still going. It's got a little bit of everything from a litigator's perspective.
In the ED&Y case, is the claim at issue specific to the swipe fees, and are the class participants the convenience stores, or are there other sort of members of the class? I could see a number of different classes of stakeholders.
So both the fees themselves and all of the rules by which those fees are charged and administered are at issue in the Eastern District of New York case. Includes everything from around how the fees can or cannot be disclosed, whether differential pricing can or cannot occur, how merchants and the terms under which they need to accept the card. So really, all of those hundreds of pages of rules I mentioned are in dispute in the case and part of the claims there. And NACS at this point actually is an individual plaintiff and is part of a multi-plaintiff group. NACS opted out of the settlement that occurred in 2012. The one that I mentioned was overturned by the Second Circuit. But there really are two classes of plaintiffs. One is this monetary class, which is everyone who has not opted out. The other is an injunctive relief class, which, at least as things stand today, includes everyone, including those who have opted out. that will be a point of contention at some point in the litigation as to whether it's possible to bind all of these companies and organizations that don't want to be part of the class and want to litigate those claims themselves. But there are technically those two different classes, and as I said, all of it though is tied up in these same summary judgment motions that we're waiting on.
That's fantastic. Thanks so much for that overview. Are there any particular initiatives that NACS is involved in that is sort of not in the legal sector, but outside of that context?
So NACS has always tried to find ways to advocate on any piece of this that it can. So litigation has been a piece of it. Dealing with the antitrust enforcement authorities has been a piece of it. There have been attempts to organize market options. There was a merchant customer exchange which tried to get into this market at a certain point to help disrupt things. And we're very much involved in legislative efforts to reform things. Last year, there was a bill, the Credit Card Competition Act, which sought to inject literally competition into the credit card market, similar to a piece of what happened on debit cards, saying that there should be a secondary option on the cards in terms of a network. And that bill we expect to be back this year and see quite a bit of lobbying from everybody on it.
Well, a lot happening both on the federal agency, private litigation, and even, as you mentioned, legislation. So an area that we will keep an eye on. I really do appreciate your expertise today. But before we let you go, we do like to ask all of our guests a couple of questions. You shared with us at the beginning of the episode some advice you have for young attorneys, but we do like to know more about you personally. So tell us something about yourself that that those that work with you don't know.
That those that work with me don't know. I actually have a very nice workplace where the folks I work with tend to know a lot about me. So that's a tougher question. As I going back to my advice, I think working with good people is the best thing you can do, and worrying about subject matter and other things really should be secondary. So, some things you won't know or your listeners won't know are I'm a huge baseball fan. I have played for many, many years. I coached my kids as they were growing up, and remain a fan of baseball at all levels. So that's one thing out there, and I'm somewhat of a workout fanatic too. So I don't know if those things are interesting to anyone, but that's what I spend a lot of my time on.
Before we get to the curious hat, can I ask, what team did you dream of playing for as a kid?
So I grew up in Los Angeles, and I was and remain a Dodgers fan. I've also become an adopted Washington Nationals fan. I was living here before the Nationals came from Montreal and established themselves, and my kids grew up here, with the Nationals being the team. So I really have two teams now, but there's no question when I was a kid, those Dodgers teams, the 70s and 80s, were everything.
And now for our final segment, Doug, what we call the Curious Hat.
And now it's time for the Curious Hat.
So your Curious Hat question today is, do you like to dance? And if so, what is your favorite dance style?
So the answer is yes, I do like to dance. I think characterizing a style gives me more credit than I deserve. I don't think my dancing could really fall into anyone's style, but I do enjoy it.
Favorite music that you like to dance to?
I'll dance to just about anything. Listening wise, I'm usually tend toward classic rock, but if you're dancing, then, rhythm and blues and other things tend to be probably better for that.
Well, Doug, thank you again for your time today. And for our listeners, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.